Hi, everybody. Welcome to another wonderful workshop that we're here to present for you today, our valued clients and friends of Genesis. Thank you so much for being with us. I am here today with my amazing colleagues, Samantha Sharples, Kimberly Cochran, and Colin Sharples, who is a new member of our team. So welcome, everybody, and please know that we're happy to answer any questions that you have along the way. We also have some other questions that were presented prior to our webinar, our workshop. And we're calling it more of a workshop because we want this to feel like you could get some value out of it, that we're teaching you some tools, helping you with some really good, just some tools to have in your tool belt so that you can know how to navigate these uncharted waters to help you and help your family get a much better outcome as a result. So this topic today that we're presenting is Divorce Deconstructed. Now, I know many of you here at Genesis, our valued clients and friends, are not unfamiliar with the term divorce. Some of you have already started your divorce process. Some of you are thinking about it. Some of you may have already gone through it. But in any event, this is going to be a general overview of what we think could be very helpful, some guides and some terminology and things like that to help you along the way. Now, although we're in many different states, divorce in general across the country and really worldwide is very similar in that there are the same types of things that go along with divorce. There's a lot of different disputes regarding custody or money or property. So we're just going to give you a general overview. And if you have specific questions relating to your specific case or your specific state, then I highly encourage you to reach out to one of our trusted attorneys and have a complimentary consultation. That's one of the benefits of being with us today, is you'll be getting access to a complimentary consultation, which is normally a fee. But because you're here with us today, we're happy to meet with you and answer any specific questions. And also on those same lines, please note that anything that is discussed today is really meant to be not so much of a legal analysis or a legal answer, but more of a generalized answer for you. So there's really no attorney-client relationship that's getting established here today. But we also ask that you be really non-judgmental. This is a safe space for everybody. Please keep your tone and your responses to a minimum. If you need to ask any types of questions, you're welcome to do so in the chat. You're welcome to unmute yourself when we ask you if there's any other questions. If you do have a question, put it in the chat and we'll get to you. But this is a safe space, so we hope that you maintain that and maintain the confidentiality among the group members so that we can all feel safe and secure, knowing that we're all on the same page here and we're just here to help you and guide you through this process. So that being said, welcome. So we are here to talk about Divorce Deconstructed. And settle in, we're going to be here for a good 60 minutes. So grab some snacks, get a nice drink. Here in Michigan on Eastern Standard Time, we're at lunch. I know some of you on the West Coast, it's more breakfast. So if you need your coffee, your tea, or your croissant, whatever it is, please settle in and let's get comfortable. So as I mentioned earlier in the introduction, most divorces in every state start with a complaint. Now, you can call it a complaint, you can call it a petition, it just depends on the state in which you reside. But most states do differentiate divorces with minor children from divorces without minor children. I know that they're categorized differently in the courts and in the court system. And for instance, the statutory requirement in Michigan for a divorce, the process and the length of time from the time you start the divorce to the time that you can get a divorce judgment entered without children in Michigan is 60 days. With children, if you can accomplish everything you need to, is 6 months. So I know many states offer that same amount of statutorily mandated time that the divorce process should take or must take before the divorce can get entered. Some courts will waive that if both sides agree, if you've settled all your terms. Some judges will waive that time period, but in general, that's the amount of time it takes for the divorce process from start to finish. Now we're going to talk about divorces with children. So oftentimes when we're dealing with divorces with children, there are different types of custody. And we have physical custody, we have legal custody, and what are the differences? So I know that most people understand legal custody. And most states, legal custody is generally 50-50, which means both parents equally split legal custody. Now, what is legal custody? Legal custody is really who gets a say in your children's physical, I'm sorry, not physical, the medical or the mental or emotional health, the schooling, making legal decisions regarding your children's life. So that is legal custody. Now, there are occasions when the two parents do not get along. One parent will get legal custody over the other if it is proven that, look, there's no way these two parents can get along effectively. It's not in the children's best interest for both parents to have legal custody. And so that's when usually a fight or any kind of motion hearing or evidentiary hearing is used to determine who should get legal custody. Physical custody, now we talk a lot about parenting time for physical custody. I know in Michigan, there is really technically no law that says physical custody. And I put my hands in the air quotes because physical custody is really more about parenting time. Which parent has the parenting time of the children? And now parenting time is made up of how many overnights the parent gets. Now, a parent can get all the afternoons, pick the child up from school, but typically when it comes to determining physical custody, where is that child residing overnight? Which home is that child going to sleep every night or majority of nights or how many nights? That's really physical custody. So a lot of times it's split with a percentage. It can be 50-50, 60-40, 70-30. It really just depends on you, your situation, your court, the other party, how the two of you are getting along, what's in the children's best interest. But there are a lot of things that go into determining who gets the children and when. So, as I said before, the legal custody focuses on which parent is making these important decisions for your child. And that's the education, the schooling, the religious preferences, medical appointments. And if one parent is awarded sole legal custody, then they make all the decisions. But the other parent typically has a right to know. But when they share joint legal custody, then both parents have to decide that together. Now, if you're completely not getting along with the other parent, that's when the determination is made that one parent should have sole custody over the other, so legal custody over the other. So as I said before, the physical custody aspect or component is the parenting time. So if, let's just say, one parent has the majority of overnights, then that parent has primary physical custody. When determining the appropriate parenting time, we look at age of children, the health of the parents, the bond between the children and the parents, the schooling where the children feel that they are best suited during the school week. But sometimes if the children are older and they want to be with one parent during the school week and another parent during the weekend, the courts will often listen to that. But most often it's really between the parents and who can decide and who can make those decisions in terms of agreeing. If you cannot agree, then you have to go to either an evidentiary hearing or trial if it's not settled either at mediation or between the parties prior to that point. Does anyone have any questions? Not yet? Nope. Okay.
So, all right.
So I know I'm throwing a lot of information at you, but I also want to make a comment that simply because you are deciding on the school together, let's just say, you can at some point, one parent may want to move and they want to move school districts. Well, if the other parent has a say in where that child goes to school, even if it's within a 100-mile radius, most states have a 100-mile radius where they can't, they're allowed to move within the 100 miles. That other parent still has a right to say, yes, I want my child to attend that school district, or no. So if they give you pushback, if you want to move and they give you pushback, well, then you may end up going to a hearing over that decision. And sometimes the decision inures to your favor and sometimes it doesn't. So it really is guided and determined by the best interests of the child. And then if you two cannot decide between yourselves, then that decision is left for the court. So let's take a look at the next item, which is property. We have marital, we have non-marital property, and we have real versus personal. So looking at property division, so real property versus personal property. So when we think of property, oftentimes we think of our home or large items such as land or buildings, but real property is typically those items that cannot be moved, like a home, land, buildings. Personal property can be moved, and those personal property items are typically cars, artwork, fancy rugs, bank accounts, financial accounts, anything that can be easily moved. That's considered personal property. And many courts in the country will distinguish real versus personal. Now, when looking at the property division, we look from an overview of marital assets or marital liabilities versus non-marital assets or liabilities. So property can be divided in not only the real and personal properties, but also marital and non-marital. So just a general overview of what marital property is. Property that is acquired during the marriage is marital. This includes everything, even the equity in your home. In some states like Arizona, this is referred to community property. I know Arizona, California, and a few other states look at community property. And so their division is more of an equal division. Michigan and many other states have an equitable division. So that is more of what is considered to be an equitable, not equal division. It's a slight distinction, but there is a distinction. Now, non-marital property acquired before the marriage, this can also include some inheritances. Now, if you are someone who is fortunate enough to have an inheritance and you do acquire that during the marriage, sometimes an argument can be made that if that inheritance was used toward marital bills or the home or a mortgage or payments of any kind, whether it's real or personal property payments such as car loans or educational loans or anything of that nature, if it is commingled with your marital income, then there is a strong argument that can be made that that inheritance is divisible. So you have to be very, very careful when you acquire an inheritance that you keep it separate, you don't touch it, you don't use it, and therefore the other party cannot claim it as marital. Now, part of the property division also must consider whether you had a prenuptial agreement or not. Last month, we had our webinar, our workshop on prenups, and prenuptial agreements are very, very effective, and that will completely control how marital and non-marital assets are divided, how they're treated, and what is to be determined at the divorce stage. So it's very important that if you do have a prenup, that you talk to your lawyer about that. They know the terms. And if you are arguing to try to make a prenuptial agreement void, you also need to talk to your lawyer about that as well. So I kind of got ahead of myself earlier, but property division, again, most states say that marital property should be divided equitably, like Michigan. Some, like Arizona, say it should be divided equally. So equitable means more fair than not. Equal is strictly equal. So it really just depends on the state in which you reside, the state in which you filed, that you established jurisdiction to file for divorce. And most states, in most states, all courts will consider all of the circumstances surrounding the division of property when determining what is equitable, what is equal. So think of a business, when you're separating a business, you have assets, you have liabilities. A marriage is similar to that. When you take away all the emotion, you look at all of the assets, all of the debts, liabilities, anything that you have that you brought to the marriage, that you spent during the marriage, and then it's divided. It's divided either equitably or equally, and then that's how your assets and liabilities are treated. Now we're getting to a scenario, but before I get to the scenario, I really want to just talk about how these assets and debts are discovered. If both sides are open and fair and they want to be very, just cooperative, then the discovery process throughout a divorce is usually pretty uneventful. If one party wants to secrete assets, hide assets, dissipate assets, abscond or do anything like that, anything ill toward the entire marital, assets, then you need to invoke discovery, which means interrogatories, depositions, filing subpoenas, and that's when divorces get very expensive. Not only are the attorneys trying to chase after and find all of these assets for you, but it becomes a chasing game. And until you can prove the assets of the other, and until you can prove or the liabilities or the debts, it's very difficult to show the court. So if you come to a lawyer, it's very, very recommended that you find as much as you can on your own to keep the costs of litigation down, so that you're not paying your lawyer a lot of extra money to do all this work, because that is where the costs of litigation really increase, not only with respect to the child custody issue, but with money. When you're chasing after money, when you're trying to find money, when you're trying to, make it fair, that's when you are paying a lot of money to your lawyer to do all those things. So I highly recommend getting prepared. If you're thinking about divorce, try to make copies of as many statements as you can, get your hands on financials, bank statements, mortgage statements, documents, anything that you can to really be your own counsel, to copy all these things so that when you go to your lawyer, you're prepared with that information so that you're not chasing after the other party for all that information. So getting to scenario number one, I'm going to read it out loud, but then I'm going to invoke the help of our trusted colleague, Kimberly Cochran, on this one. So Spencer and Layla, and by the way, these scenarios are not from our clients, but they're sort of based on some real life scenarios, but we've kept names and some of those other things hidden. We've been doing this for cumulatively for about 50 years. So we have a lot of hypotheticals that we can share with you. And we've seen it all, by the way. So Spencer and Layla have been married for 7 years. Although they care for each other very much, they have decided they no longer want to be married. In hopes of having a quick, easy, and painless divorce, they are trying to come up with an agreement on their own. Spencer has 3 homes titled in his name, all of which were purchased between 6 and 8 years ago. Layla does not own any homes, but she did purchase several antique pieces of jewelry and a new car within recent years. Together, the couple owns a lake house, a few cars, and several expensive art pieces. They do not have any joint bank accounts, and they both have several different investments and retirement accounts. What types of things, Kim, do they need to consider when dividing their property?
First of all, hello, everybody. Number one is make a really detailed list. Each of them should sit down and start at the top. Here's all of the real property I purchased, and Sabrina defined real property earlier. All of the major personal property. And in this example, Spencer has some homes that may have been purchased before the marriage and some that may have been purchased after the marriage. And he'll need to identify maybe purchase dates, if he can get some supporting documentation regarding when exactly those items were purchased. That would be very helpful. Investment accounts, it would be helpful if they had a statement from those accounts as of the date of marriage, because they can see if any of the money that's in those accounts was premarital coming in. They don't have any joint bank accounts, so that's not an issue. But yes, documentation, a list, that's the very first step, is to identify everything and possibly determine a value. And if appraisals are necessary, then maybe appraisals are necessary. But one thing that caught my eye in this example is that even though Spencer may have purchased that one of the houses or more of the houses before the marriage, if he used any money, marital money, during the marriage to pay property taxes, or to maybe put a new roof on one of the houses, or just take care of homeowners association fees, maintenance, what have you, that property, even though it was purchased before the marriage, could be a marital asset. If that would take some investigation though. So again, documenting everything is the first step. And then if anything was inherited, Sabrina alluded to that earlier too, that could possibly be separate property. But if any of the funds from that inheritance were used to fund marital expenses, then maybe that inherited money that was used to buy a house or to buy an antique piece of jewelry or artwork, what have you, maybe it's no longer separate property anymore. But the important thing to remember, though, that anything that's purchased during the marriage is usually considered marital property. So those are the things that are going to be either divided equitably or equally, depending on your jurisdiction. And parties working together is the best way to get this resolved, instead of trying to fight this out at mediation or trial. That's for sure.
So Kim, we get a question all the time, or often, and maybe some of you here have the same question, that when a home is titled in one of the people's name, one of the couple's, names, not both, not jointly titled, does that have any significance? And I know you answered it, but could you please elaborate on that, the significance of a title, for instance?
Sure. If it's a title, if it's a piece of property purchased during the marriage and it's only titled in one person's name, it's still considered marital property because it was purchased during the marriage. One partner may not have as good a credit as the other, and maybe that's the reason why a loan was obtained in only one person's name, so that therefore then the deed only has one person's name on it, but it's still marital property if it was purchased during the marriage. And even if it was something like one of these houses, if Spencer purchased it in his sole name before the marriage, it still may be titled in his name, but it could become marital property if certain things happen.
So essentially, everyone here today, ladies and gentlemen, the titling is not always relevant. So people get afraid, let's just say if we get a lot of, stay-at-home moms that come to us that are fearful because the husband put everything in his name, not joint names. So we can prove otherwise, that you do have, a say, or you do have rights to that property as well. Simply because the title is in one name does not mean that you're excluded from that asset or the division of that asset. So thank you, Kim. That was awesome. Anything else? Would you like to add anything, Sam?
I do just want to ask one more question for clarification, Kim, if you wouldn't mind. That last sentence there that says they don't have any joint bank accounts. The fact that the bank accounts aren't joint, is that relevant here, or can they still be divided if they're only in one name?
Yeah, that too. That it's again, like Sabrina was alluding to just a moment ago, if the husband or the wife has all of the bank accounts in their sole name, it's still considered marital property if those accounts were funded by either party individually during the course of the marriage. So no joint bank accounts, but Spencer's individual accounts, Layla's individual accounts, the monies that were in and out of those accounts during the marriage is marital money, even though they're titled in separate names.
Thanks, Kim.
Thank
Yep.
you.
So moving along to child support and spousal support, which is basically the financial aspect, the financial support side of a divorce. So child support, remember everybody, is for the children, not the parents. We get that question a lot. We get a lot of concern because one of the parents paying child support is concerned that it's going all toward the one parent. But it's really for the children. Each state has its own formula to determine the amount of monthly child support. Considerations in that formula, and again, the formula is very state specific, but it's usually statutorily based. The number of overnights is what's the determining factor, the amount of money for daycare, health insurance costs, income of the parties. Now, the reason why overnights is significant is because, again, that's where the child lays his or her head every night when they're sleeping. But I have seen, and we've all seen here, deviations in the child support formula. If, for instance, one of the parties is getting the child after school every day and having them from 3 to 8 every day after school. So different calculations can be done. If proven, a judge will allow it or grant it. And different considerations can be taken into account for the child support. If the number of overnights is a little bit more disparate or not as fair, and one parent is actually taking, the child a lot more, just not perhaps overnight as much. So different considerations are looked at, but typically and generally across the board, the considerations in the formula are those that were just mentioned earlier. When looking at the support of the other spouse, we call it spousal support, some states call it alimony, it's essentially the same thing. So each state, again, will have its own enumerated factors that are taken into consideration when determining alimony or spousal support. The key factors of that are the ability to pay, what was the level of income, what is the level of income now, what can be proven is the level of income now. That's another thing. So if you have a really vindictive spouse who's trying to hide a lot of assets and who's hiding their income, or all of a sudden takes a significant pay cut until the divorce is finalized because they're super vindictive and they don't want to pay the spouse anything, you have to be very sleuth-like, be very vigilant, try to get as much proof as you possibly can that they're just doing that as a shell game to not pay you as much. But again, you have to prove it, right? So be your own counsel right now. See if you can get as much, as many of the statements as you possibly can. But spousal support and alimony are very different from what you're entitled to under the division of your marital assets, the marital estate. That's separate. So alimony is a separate category like child support in determining, in the factors that are used to determine what that amount is. Most states, alimony is very negotiable. So while there are certain formulas that are used to establish what a fair number or a reasonable number is for alimony, oftentimes that number is negotiable. So it's usually paid monthly. It can be paid in lump sum. It can be paid in, they call it alimony in gross, which is all up front. It can be offset. Certain things, perhaps that person doesn't have the means to pay spousal support like that. But what they could do often is maybe give them more of the equity of the house than which they are entitled to under the marital division. So it is derived, it can be derived a number of ways. So, you know, there's no hard and fast rule about it, but just keep in mind that if you've been married a significant amount of years, spousal support is typically awarded. It's a lot different now than it used to be because now both parties are able to typically work. If one party cannot work for whatever reason, that's taken into consideration. But generally speaking, spousal support is more negotiable than child support, and it is separate from the marital division of the assets. Which brings us to another scenario. So I'm gonna read this once again, and if you have any questions, please put it in the chat, and we're happy to answer any questions along the way. And this is just gonna be a little friendly reminder that stay till the end. We're gonna be pulling one of the names from our attendees today for the wonderful $10 Starbucks gift cards, just for being here today with us. So it's our way of thanking you for taking an hour of your time. And hopefully one of you will be the winner. You'll remain at the end. But okay, so we have a question as it relates to the determination of the spouse's income. Does the calculation include potential income? It can, if it can be proven that that potential income is more likely than not to be received. A lot of times that is looked at when perhaps bonuses or we see that a lot in the sales world when one of the partners has a sales job and they get commission or bonuses based on their performance. So oftentimes we work in a contingency plan such as, you know, 10% of that bonus or 10% of that commission will be given to our client, for instance. Or maybe not 10%, maybe 5%. I guess it just depends on your scenario and what is reasonable, what is going to be used. We have to negotiate that amount. And a lot of times that percentage is determined based on what that other alimony is getting, you know, that you're getting, whether it's alimony in gross, whether it's a monthly payment, bi-weekly payment. So depending on what that is, will depend on what that percentage is or should be. So, you know, if the one party, the opposite party, the opposing party is saying, you know, my income completely dropped, I'm poor, I can't pay you, but then you know, that's not true, they're lying, they're just hiding their assets, well, then we can write that in the judgment saying, okay, look, or the settlement agreement, you are entitled to X percentage of whatever proceeds they're going to be getting, whatever income they're going to be getting, whatever bonus at the end of the year they're going to be getting. And they can only hide it for so long, even if they put it in their partner's name. There are ways to discover that information, and there are ways to protect you and your future from any type of, you know, bad behavior, let's just say. So scenario 2. After being married for 20 years, Elizabeth came home to find Mark in bed with another woman. Furious, Elizabeth has decided to file for divorce right away. She has put up with Mark's crazy behavior for years, and she even chose to stay with him even after his most recent domestic violence charge. Wow, she's put up with a lot. So we see that a lot. So she's really, really angry. She put up with all of that. Now she comes home, she finds that he's in bed with someone else, no longer committed to their marriage. So now she's compiling all of her documents, which is what I told you guys to do earlier. Take all of those documents and information to her attorney. She's uncovered that Mark has been spending thousands and thousands of dollars on hotel rooms, gambling, expensive jewelry, and everything else that she is finding out. So, Kim, can I ask you this next question?
Sure.
Do you think Elizabeth will be entitled to spousal support payments from Mark?
Knowing just this, I would say yes. There's some other things, though, that we would need to find out for sure. I'm not really sure what the law is in Arizona, but in Michigan, there are several different factors that the court looks at to determine spousal support or alimony payments. 20-year marriage is a long marriage, and that's one of the factors the court considers. And that is, Elizabeth would probably be entitled to some amount of support just for that mere reason, if everything else is equal. If she does have an income that is similar to Mark's, maybe the spousal support would not really be there, because if they each have their own income, same amount of income to support themselves and to pay for their daily living expenses, then maybe spousal support wouldn't be on the table. But then when you factor in Mark's bad behavior, that is a big kicker. You look at the conduct of the parties during the marriage when you determine spousal support in Michigan. And if he is spending a bunch of money that is for non-marital reasons, on hotel rooms, gambling, gifts for significant others, what have you, that is a strike against him. And especially too, the domestic violence charge. I'm not sure if that was against Elizabeth or somebody else in the household, but that behavior is definitely a strike against him. So I would say she probably would get some type of spousal support especially if she has a lower income than Mark. And fault, Michigan is a no fault divorce state. So you might say, well, that's, fault isn't considered. No, it's not really considered, but the court will look at a whole bunch of things like this and say, wow, maybe Elizabeth should get something different than what Mark would get in this settlement, because all these things together have pointed more towards Elizabeth's favor. So the court doesn't weigh each of those things equally. And again, I'm not going to go into all the different factors, but length of the marriage, health of the parties, the ability of the parties to support each other, possibly fault, the conduct of the parties during the marriage. Those are the things that the court considers. And she definitely needs to get away from him, that's for sure.
So Kim, I know you brought that up, which is great in terms of no fault. How does no fault, work with the conduct of the parties and the fault? So I know you touched on that briefly. But if there's no money, if Mark spent all of his money and all of their money, what is she to do?
What they could resolve this issue by, like if there's a house involved, maybe somebody's going to keep the marital home and the other is going to move out. The one that is keeping the marital home would be, so if Mark keeps the marital home, he has to buy out Elizabeth's interest. And maybe if she's entitled to, let's just say round numbers, $50,000 for her interest in the marital home, maybe to compensate her for these bad acts of Mark, maybe she gets $75,000 in equity and Mark only gets $25,000 in equity instead of $50,000 each. If the marital home is going to be sold, no one's buying anyone out. Maybe once it's sold and they get the net proceeds in hand, again, they can divide those funds more towards Elizabeth, less towards Mark, to compensate her for these bad acts if there is no money in the bank accounts to pay her for those bad acts.
Well, thank you, Kim. And that's exactly what I was talking about earlier, that how spousal support can be negotiated and offset with certain equity and certain things of the property division. But giving you a scenario kind of helps to understand it in a little bit more practical way. So thank you so much for that, Kim.
Sure.
We have a chat question in our chat. In regard to spousal support, and I'm going to ask Samantha this question. And thank you for this, Ms. Gomez. In regard to spousal support, if a spouse removes the other spouse, who is a stay-at-home mom, as an authorized user for a joint credit card, which was used to purchase daily essentials such as food, gas, medical care, what should the affected spouse do?
So unfortunately, this scenario it happens more often than we'd like to think. And it it makes the divorce process a lot more complex, a lot more complicated, and there are several different ways that maybe we could try to address this issue. You know, if there's another credit card or a bank account or some other access to funds that the spouse who is staying home is able to, you know, pull funds from to continue paying for the daily essentials, that's an option, because when you're married, it's your money. You need to be able to live. But, you know, sometimes that's just not possible. And in that circumstance, it's really important to talk to your counsel, whomever it may be, during your divorce case, to see if they can reach out and try to work things out. And perhaps it comes to the point where a motion may be necessary to go in front of the judge and say, Judge, we need access to the marital funds, or we need something called interim support, meaning when the case is happening, we need monthly payments to allow for the spouse who lives at home to provide for themselves and perhaps the family if there's any children involved.
There are certain safeguards too, that depending on whether you were the one who filed or whether it was your partner who filed. There are certain things, if you file first, or even if you counter sue, and you were the defendant, now you want to be the plaintiff or the petitioner now, you can file what we call orders or ex parte orders, motions for ex parte orders. It depends on the jurisdiction in which you reside. But to protect yourself from the other person doing that, we call them status quo orders. We call them dissipation of, you know, asset orders, protecting, basically orders preventing the other party from dissipating assets, secreting funds, like an injunction, so to speak. So, but both parties are bound by that order. So that means that both parties have to be on the up and up and, you know, be good boys and girls, play nice in the sandbox. But sometimes another party will defy that court order, but then you still have that piece of paper that protects you to go back to court again and say, look, judge, he continues or she continues to violate these court orders. Then you have more standing, you have more basis in which to build your case. And the more often you go back to court, I know it's time consuming, it's expensive, it's tedious, it's exhausting, but the better your outcome. So if you continue to let things go, and don't bring this up to the attention of your attorney, well, then come the end of your case, it's very hard to make up for all of that lost time, lost arguments. While it's happening, it's way better to take care of it. Even if you might think it's small, bring it to the attention of your attorney, because if it accumulates over time, then you'll have more of an argument to make. But if you wait too long, sometimes you've let the precedent, it's set a precedent, and it's too hard to get all of that traction back. So please make sure you keep track of everything, you talk to your lawyer about everything, then you can discern what you should do and for your particular situation, because you don't want to let things go too long, because courts speak through their orders. So until and unless you have an order from the court, it's really difficult to force the other side to do anything. So make sure you protect yourself by getting a hold of all that information, bringing it to your attorney, and letting your attorney make the decision with you in a very structured, very, reasonable manner, so that you know what you need to do and how you need to do it. So, which brings us to our last stop. Stop number 4, we go to trial or should we settle? So a lot of this really will depend on your specific scenario, but the majority of divorces settle before going to trial. And that's really because a lot of judges now want everyone to settle. They don't want you to be in court. And they do provide a lot of alternative dispute resolutions prior to going to trial, because they do want you to settle, because no one wants to decide a domestic case, right? Nobody knows your situation better than the two of you. Nobody knows your children, if there's children involved, better than the two of you. And settlement is private, it's personal, and you can be creative. If you have good lawyers by your side, you can really settle your case amicably, smoothly, hopefully with as much or as little disruption to your personal life as possible. But in fact, most states will require you to engage in some type of settlement discussion prior to any trial taking place. So if one side or one party is absolutely unreasonable, then there may be no choice but to proceed to trial. And sometimes we see that when custody is at issue, one side is totally unwilling to settle on, 50-50 or 60-40, and the other party really deserves to have a child custody and they don't deserve anything less than 50-50. Well, then sometimes trial is necessary. Similar to assets, if one party continues to dig their heels in and doesn't want to pay child support or spousal support, or even divide the assets equitably or equally, then you may need to go to trial. But be sure to talk to your attorney about that, because trial can be very, very expensive. So you need to really look at whether it's worth going to trial, because the cost of litigation oftentimes exceeds the value that you're arguing over, whether if that's money. Now, of course, you can't put a price on child custody, right? You can't put a price on how many overnights or how many days you want to see your child. But if you're arguing, if you're going to trial and it's going to cost you 60 or 70 or 80 or even higher to try to go for, because you want that one more overnight, you might just want to settle. Or if you're trying to litigate and go to trial over, say maybe $500 more in child support a month or spousal support a month, but you end up spending over $20,000 in trial, that's several years of a $500 a month payment. So you really need to look at all of the factors with your lawyer. And instead of having a lawyer that will just fight for the sake of fighting, you want to look at the overall holistic picture of you and your family life and your child's life, because only then will you be able to make that really good determination whether you should go to trial or whether you should settle. But make sure you look at it very openly, without emotion, and make sure you take into consideration all of those factors.
And Sabrina, I think that this does touch on one of the questions that was submitted to us beforehand, very follow what you just said. Somebody asked if we could answer, what am I supposed to do if I don't have money to pay an attorney because I was the homemaker in the marriage?
That's a great question, Samantha, and I was actually going to ask that question of you, but I will answer. And oftentimes when a spouse doesn't have money, let's just say they were the stay-at-home mom or the stay-at-home dad, and the partner was the, breadwinner, was the provider. What many attorneys will do, and we at Genesis will do this as well, is we'll file an immediate motion to get those payments paid for by the spouse. So that's not uncommon, but what I highly recommend that you do is to save your money in the interim. If you think you want to file for divorce, if you want to be the one filing for divorce, then you save as much as you can, hide it away, put it away, give it to a trusted friend or family member, save it so that you can put the initial downstroke, because most attorneys do require a retainer. So if you can pay the initial retainer and then have your other legal fees paid for by way of a motion, because you have to ask the court's permission for the other party to pay, because they're not just going to pay you. But if it's all coming out of one pot, then you file a motion typically for attorney's fees and you make the other side pay. Now, that can be a tricky thing though. So just make sure you try to take care of yourself and either borrow the money, save the money, do everything you can to pay for that initial downstroke. Now, if you're on the receiving end of getting a complaint for divorce or a petition for divorce, depending on your jurisdiction, then immediately you're going to have to petition the court for those attorney's fees. And a good trial attorney, a good divorce attorney usually knows how to do that, but that's not always guaranteed. So if you can't get those fees paid for, then you might need to take a loan or save your money or find a lesser expensive attorney that will take it out of perhaps a home sale at the end. But that's usually more rare than not. So do your best and try to save as much as you can for your own protection. Sam, is there anything else you'd like to add to that?
I think you covered that very well, and I do think too, something to take into consideration. Attorney fees are expensive, but just remember both parties are paying those attorney fees. And sometimes that could be something that we use when we're talking about the settlement versus trial aspect. A big thing to consider, like Sabrina was saying, the cost of settling versus going to trial. It's going to cost you a lot of money to get to the trial point and even more money to go through that trial process. And that may be a bargaining chip that you and your attorney are able to use if you happen to be someone who is incapable of paying those fees. Or honestly, even on the other side, you can say, I'll pay X amount towards your attorney fees if we settle these other things. It's a big chip that is used, especially because it's not always guaranteed that the court is going to award those fees at the end.
So moving along to our last scenario. So Becca and Luke have been involved in a highly contentious divorce, and trial is quickly approaching. They've been married for 15 years and they have 3 children who are all still minors. Luke has always been the main provider for the family, but he recently went to jail for his 3rd DUI, and Becca is using it as an excuse to leave him. Despite the fact that they have already spent thousands on legal fees, Becca is pushing for full custody of the children, $4,000 of spousal support every month, and she wants to keep the house. Now that's a high figure, so that means that perhaps he's making that kind of money. But Luke is beside himself because he feels as though he's throwing away all of his hard-earned money only to fight a losing battle. He definitely wants to give Becca whatever she wants because he feels so badly about his DUI, but Luke's attorney is encouraging him to attend mediation because he doesn't want to settle for everything that Becca is requesting, because he thinks it's still too much, even though he wants to do everything he can to, be kind to her. So what do you think Luke should do? Should he go to trial or should he try to settle? Sam?
Well, so this is this is a pretty big scenario. There's a lot of factors here and a lot of things that we need to consider. And given the facts here, myself, I would think maybe Luke should listen to his attorney and think about attending mediation. There's some big issues here. I mean, that 3rd DUI is really important. That's the kicker, in my opinion, in this scenario, because that DUI, 3 DUIs, and having those small children. I mean, we talked about earlier in the presentation, Sabrina, you touched upon those different fault factors for the spousal support. You touched upon how that could affect custody, overnights, all of these things. And depending upon what Luke is looking for, does he want more custody with the children? Does he want lesser spousal support payments? He's going to have that conversation with the attorney about what's really attainable depending on the laws of his state. And, it's something that DUI is weighing against him, but based upon the figure of spousal support too that Becca's asking for here, it looks like he's the primary breadwinner in the case. And the other thing is, if Becca truly wants to keep the house, then maybe Luke can leverage something else. Maybe in mediation, he might fare better than in trial. He'll save some of that hard-earned money and be able to work something out where perhaps Becca does keep the house, but she receives a lesser spousal support payment, like Sabrina and Kimberly were saying earlier in the presentation. Or perhaps they look for another scenario where instead of monthly payments, Luke is able to give lump sum and kind of move forward with his life and handle what's going on with this DUI. I think mediation would probably be better for Luke in this scenario.
So I would like to ask each of you to put in the chat, what do you think? And also with respect to the children, in my opinion, child custody here is very significant. So if she wants 100%, of the parenting time, do you think that she should get it? And I'm curious to see what your answers are. So we have a lot of situations like this where there's either an addiction problem, a drunk driving problem, which is obviously an addiction issue, or if someone's in jail for a period of time. One party really pushes hard for 100% custody. Now, I will tell you, in Michigan, and I know in Arizona as well, they are looking more and more at, both parents are significant in their children's lives. So in this situation, if Luke does lose some parenting time over this, if he had a good attorney, his attorney would fight for perhaps a stepped up parenting time schedule, parenting time that increases over time as the children get older. Or that there are certain, parameters in place where he has to blow in his car before he can drive the kids. Or he has to prove that he's sober somehow. We have that a lot where there's, even between the parties, even if there's no criminal action, the other party wants that assurance. So remember, it's not to be vindictive, but it's to do what's in the best interest of the children. And if it's determined that it's in the best interest of the children for Becca to have full custody, well, then that's what should be done. But if that's not determined, if this DUI is really just sort of a blip in the road of Luke's life, but he really wants to see his kids, he's trying to get sober and do what he possibly can do, and he's a great father otherwise, then the court is more inclined to give him that stepped up parenting time schedule. So I'm just curious if anyone had any other ideas as it related to that, but I see there's a question unrelated to the parenting time, but I will go ahead and ask it in terms of this question. I believe it's with an injunction. So if the divorce process has been started and an injunction is in place once taxes have been filed, are you able to withdraw half of the refund amount once it is deposited to joint marital account? That is something that you need to discuss with your lawyer and with the two of you, because if you pull it out and he doesn't, or she doesn't, depending on if you're married, same-sex marriage, then you need to not defy the court's order. It really depends on what the court order says, but if you are both enjoined from depleting those funds, then, or depositing it, you simply because you do it, you need to have the permission from the court is what I'm trying to say. So, and two wrongs don't make a right. So if he does it or she does it and you are wanting to do it, you still shouldn't do it unless you have permission from the court, because you can't claim that they're doing something against the court's order and then you do it, but you can't point the finger if you're doing it as well. So try to always follow the court's order, but get permissions from the court or your lawyer. Make sure it's in writing that you're able to do to withdraw your half of the refund. There's another question that came, since this is our last scenario. There's another question that came up before in one of your RCPs. If the divorce process has already started, can I still request to change my legal surname back to my maiden name? And yes, and you can, as long as it's done before the final judgment of the divorce, you certainly can. I mean, you can always change your name even after the judgment is entered. It just is more hoops to jump through. It's like just changing your name, as anyone would. You just have to show your judgment of divorce, show all your legal documents. You can really do that at any time, but it's easier and more efficient to do it prior to the judgment being entered. And what we like to do in Michigan is enter a separate, or have prepared a separate order, so that when you go to all the different entities, whether it's the Secretary of State, Social Security Office, you don't have to show your entire judgment. You just show the one page of the order saying that you have the court permission to change your name from what it is to what you want it to be. So that being said, we are so happy that you joined us today. And we're now ready, drum roll please, for our big withdrawal. I mean, big draw of our name for the winner of the Starbucks gift card. So Colin, if you will, bring up the paper. All right, here we go. Let's see who's gonna get it today. Allison Gomez.
Allison, congratulations.
Congratulations, Allison. Thank you for being here with us. And is there one more chat? Oh, thank you. Yes, we'll be sending that to you, most likely via email. So be on the lookout for that. And if anyone has any questions at any time, please don't hesitate to reach out to us. We are always available for you 24/7. Send us an email. And again, mention that you were here and we're going to send you a special RSVP for a complimentary consultation. Join us on all of our social media platforms. Genesis is available all over. So if you have any questions, please reach out. And thank you again for being with us. We're grateful. We can't do what we do without you, our valued clients, and friends of the firm. Thank you so much, guys. Have a wonderful day, wonderful week, and be well. Bye.